Joining us today, we're so excited to have him with us, is Reuben Ortega. He already did a presentation for our A&E firms, and I'm very, very excited to have Reuben back with us today. Welcome, Reuben, and we look forward to learning from you again about the pitfalls of contracting. So welcome, and thank you for being here with us with our construction PortGen.
Thank you so very much. I did notice as we were getting started here that Tamika from the Port of Seattle came back, and I would be amiss if I didn't give her a chance to speak. I appreciate her support for this great event. So if she wants to jump in at any point, I'll let her. But I'm glad to be here. I tried to join a little bit early in that previous session so I could see what everybody was involved with and maybe how we can craft or customize this presentation, some of my talking points to your specific situation. So one of the things I wanted to just put out there right up front is not often that you can just ask an attorney anything. I won't tell you my weight or my height, but besides that, feel free to ask any questions you have, and we can. Okay, so it's 200 pounds. I'm 5'10", so everything's out there now. It's out there. But we're gonna start today talking about some contractual language and basically how to avoid conflict. I think I recognize one of the participants as well. I think Victor knows me, if it's the same Victor that I know. So turn on your camera or say hi if you get a minute, Victor. It'd be nice to chat again. Let's start. Let me, I guess I probably should share my screen so everybody can see, so I'm not talking in the wind here. How best to do that? Here we go.
Hi, good afternoon, everybody. Reuben, as you're getting your screen together, this is Tamika Thornton with the Port of Seattle. I was going to make a comment to Rose really quick as she was talking about her potential to subcontract some work out. And since Reuben is an attorney, this may actually be kind of a segue into what he's talking about. If you are going to subcontract work out and you have a contract initially with the prime, then everything in your subcontract should mirror what you have in your initial contract. Again, barring some information, because as Tanya said, again, you will be liable and you don't want to have any potential risk that you can foresee, which is why a lot of times the prime contract is so convoluted, as we always hear, even at the Port of Seattle. Because again, we're trying to minimize our risk, but at the same time make money. And again, you want to minimize your risk and make money. So Reuben probably can speak to that a little bit more, but that's always been my philosophy, is whatever's in your prime contract, you mirror it in your sub. So thank you, Reuben, and I will give the floor and screen back to you. Thank you.
Oh, you're good. Thank you for jumping in like that. I appreciate you. Want to make sure, can we get some nods? Can everybody see my great splash screen here?
We sure can. Thank you.
Great. So let's address that first and foremost on the subcontracting. It is so important, not only because government contracting puts obligations on companies, that subcontracting, you try to pass and say, I'd like X job done, but you forget to pass on the insurance requirements, or you forget to pass on the bonding requirements or the timing requirements or whatever they are, and you end up getting yourself in a pickle. The thing that I actually dealt with this week was not with a subcontract, but with a third-party IT support company. My client wanted to bring in some IT support. They hired an outside vendor. All they're really doing is managing their 10 laptops that they have for their company. And the government contract that they have to do marketing for, we'll just say someone in King County, it required that they have these very specific data protection and data provisions, and it didn't allow them to assign that to a third party. And so we had, even when it's not dealing with subcontracting on a project, just the fact that you're doing business with government entities, there's a lot of obligations and a lot of things we got to pay attention to. So happy to talk more about that. And I loved the question we left with at the end about when is the right time to subcontract. After we go through this a little bit, we'll come back to that. Rose, don't let me forget, okay? So try to get my screen so I can see as many faces as possible. I feel like everybody's kind of got their screens off, and that's okay. If I call out your name and you want to give a thought here and I don't see you, let me know. Speak right up. So let's talk today. We're going to talk about prevention versus cure. It's so much better. Being here today, you have the opportunity to get some ducks in a row ahead of time, hopefully, or to at least think about things that maybe you haven't thought about before as you are in business and you're growing and you're getting more complicated projects. The biggest and most important step is for you to take and go, okay, well, let's see what I can do today so it doesn't cost me tomorrow. And that is, it's a hard thing to do because we're all business owners. We're all running with our head down, trying to make things happen. And being able to step back and detach a little bit and look at the bigger picture provides great value, but it takes some extreme discipline. So let's talk about preparing for effective disputes. I love this phrasing because a dispute is an argument between two people that only the lawyers win, typically, right? If you're going to have some sort of friction in a contract or in a business relationship, what you want is that conflict to be as quick and as painless as possible for both parties. Otherwise, you're just paying for attorneys' time and energy and effort. And though I appreciate the job security, there's plenty of work for me to do. So let's see if we can minimize it today. So 3 things that I want to talk about today is knowing our contract, knowing the people who we're contracting with, and knowing what's out there as far as liabilities and claims so that we can allocate risk properly. My overarching and golden rule when I'm dealing with construction contracts and the trades generally is that they're typically not very organized. They're really good at their skill. They're really good at their job, but for some reason, organization and keeping things tidied up and track of things doesn't always happen. And so I really enforce my clients to get organized beforehand and be organized during the whole process of the job, of the project, right? If you have change orders flying around or bids flying around and you don't have a process or a person in charge of keeping things organized, or a front office person who is your brain to do that, that's worth their weight in gold, because there's nothing worse than saying, so-and-so sent me an email or sent me a text message or said to me while I was on the job site that we didn't actually have to do X, Y, or Z because that was too big of a pain in the neck. And so we didn't. And I'm sorry the roof collapsed, but we were told we didn't have to do that. And not having that, not having the ability to pull up that text message or that email or that change order really quickly and in a way that you can actually back that up can cost you hundreds of thousands of dollars in lost time, energy, and maybe even projects if your bond gets tapped for it. So I think that's very important. Kurt, thanks for turning on your camera. How are you doing today?
I'm good. How are you?
Wonderful. What do you do?
I'm a engineer, project program manager.
PM, huh?
PE, PMP, yeah.
PMP, yeah.
Jack of all. Like I said earlier, I do design, build, as well as construction work in the water resource and environmental side.
Gotcha. Wonderful. I so understanding from my experience, you're more than a jack of all trades. I effectively consider you a master of all, but that's typically what I see in this world. How many contracts do you think you touch in a year?
I'll touch probably the next year.
Yeah, or this past year.
What
I mean,
am I
2020
planning
has
on
been
doing,
weird,
or what
right?
have I done?
Typical.
That's
Yeah,
that's the
typical.
better. Typical. Well, we're Lesnoy is we've got a very good upward trajectory. Did probably touched 8 to 10 this year,
Yeah,
and then I'll probably hope to touch double that next.
and that's a lot. And that's a lot. Typically, my clients will touch 3 to 4 in a year, right? And there'll be big ones, and they'll call me in. They'll do a lot of little stuff. But with all of my clients combined, I'm probably hitting 300 contracts a year I see. And that experience and that view lets me be able to look at a contract quickly and know, one, if the party's sophisticated, two, if the contract's one-sided, and knows how to, I know how to narrow in really quickly on what the contract surprises could be. So I think that as you are, do you have a responsibility as you're in the design build side of it to make your bids compliant with the contract, or you typically get the contract afterwards? Is it chicken and the
No,
egg?
we're on the front end,
Okay.
and that's probably one of my biggest learning curves is getting a handle on the federal and military contracting, which is what we do a lot of right now at Lesnoy. So
Dealing with the FARs and the DFARs. Do you have to?
yeah, and so some of it that I'm managing is not necessarily my technical area of expertise when it comes into environmental, like quality testing, aquifer, and environmental stabilization and stuff. So I manage some of those projects, and just the contracting on the federal side definitely gets hairy.
Yeah, no, it is. And the hardest part about the federal contracting is it's 9 times out of 10, it's take it or leave it, because they're not going to take liability and they want you to deal with it. And so I found that I typically advise my clients there's 3 ways to allocate risk. You can contract around it, you can insure against it, or you can just know what it is and go in with your eyes wide open. And so oftentimes when I review, especially federal contracts for clients, it's a lot of teaching, it's a lot of learning. It's like, well, what does this mean when when it says I'm liable for potential criminal liability for, wastewater provisions in the EPA, right? Well, yeah, this is what it really means. And so I think that, part of knowing your contract and knowing what you're getting yourself into has to be high on the priority list as you're trying to make, secure these jobs, because it doesn't do you any good to get to a job and not be able to fulfill the obligations, or make your company worse off because you've made now promises you can't keep, right?
Right.
So I appreciate that. Thank you for chatting. So as I'm outlined here, knowing your contract, I think that there is some things that people forget as they're looking at their contract. There's a lot of times where there's other documents referenced, or even policies that'll be referenced in the contract that says, hey, you have to uphold our data and use policy, or you have to comply with our COVID policy nowadays, right? And oftentimes they don't ask for those. We don't look at them. We go, oh, it's a policy. It's going to require somebody to go get a big human resource manual or book, and I'm going to look at that as well. And I'm just not gonna look at it because it doesn't matter. And that gets people into a lot of trouble, right? Oftentimes what I find is it's very helpful for a client to understand all of their obligations and then to carve out the risk that way. So I've often, when there's onerous policies that they want us to implement, like you're going on site and they want you to make sure that criminal background checks. You have to have security clearance to do certain sort of jobs, right? Well, that obligation can be mitigated because you can say we can have one person there with the clearance monitoring everyone, or 1 per 3, and they'll modify and give you a carve out on these policies if you just ask for it. But if you don't know it's there, you end up getting in trouble because you don't know your whole contract. And if you don't know what you're getting into, you can't negotiate around it. So one of the things that I typically like to understand from my clients' perspective is the type of contracts they prefer to get into, right? Whether they're looking for, you know, lump sum, time and material, whether they're doing a design build or just the design part, or they're just consulting on one aspect of a bigger project. It makes a difference, because if they typically have done certain types of contracts in the past, then that lets me understand kind of where their ability to be compliant is, right? It's like a kid learning to ride their bike, right? If all they've ever ridden is with their training wheels on, then you know, and if they're handed a bike without training wheels, it's going to be a learning curve. And it's better for me to understand kind of what they know and what they've done in the past, so that as we go look at these contracts, we can say, okay, this is different than what you've ever done before. You have to, you know, you got a guaranteed maximum price. No matter how much money you spend, you could end up in the hole here, because this is all they're going to pay you no matter what. A lot of times for those remediation contracts, if you're doing a bunch of environmental cleanup, those will be maximum price contracts, because they know that it can be really expensive, and you might have to, you know, dig down and remove a lot of earth. So
When you
that's
say maximum price, that's what I mean. We always call it firm fixed price, but same
sure,
idea, I
same
believe.
deal. Yep, yep. And I think that those are the most, from my perspective, risk reward, right? Like, it's a high risk because you don't
Right.
know what you're really getting into, but you could make out like a bandit if you're good at what you do and you've done it a lot.
Mhm.
So I think with experience, those are really good to get into,
Yeah,
because
we're doing a lot of it's either those or cost plus in the federal side
yeah, yeah.
of the project.
And I think that, you know, each of those contracts, not only from an economic standpoint, have some different terms in them, but again, if you know the tone of these contracts, you'll understand kind of where your indemnification lies. You'll understand where your limitation of liability is probably not existent on some of those, and that helps from a planning standpoint as you go and get a contract the second time or the third time. That's another, you know, cost plus contract. You go, okay, I know exactly what it is. I know I need to go back to, you know, making sure I'm super organized so I can track all of my costs, right? Because if I lose track of the costs, or somebody doesn't turn in some receipts, or I can't prove it and I get audited, then I'm going to, you know, trip that provision on that cost plus contract, and that cost is going to be excluded because I don't have the right documentation for it. And so knowing that beforehand, before you get started on your job, of what kind of contract obligations you have, and prepping your team, right? I think that that's one thing that lawyers, at least I've found, are really good at giving legal advice, but it's really the business owners that are really good about translating that into actionable, practical things that they want their employees to do, so they don't mess up on the contract. And that working with business owners in that way, so that they can take the contract, understand the risks, and then translating that to their employees, I think is the funnest part of my job. To be honest, I don't really enjoy looking at the 60-page government contracts, but I like taking those and helping the business owner implement some real, you know, procedures and policies to, you know, SOPs, right, to be able to handle their obligations under the contract. So I wanted to give you guys a couple examples of where this is kind of bitten clients in the butt. These are actual cases, not my clients, but real cases. So contractor signs an indemnity provision thinking that they're going to be just fine. Contract basically this is a standard boilerplate language. This is probably been in contracts for the last 30 years. And when the Austin company got charged for $1.3 million, it shocked the legal world, because it was thought for a very long time that when in Washington, at least, when you're getting indemnified, that's dealing with, you know, if part of it's your fault, then you're just out of it, right? But this concurrent negligence interpretation the court came down with and basically said, look, if you're going to get indemnified, then that means even if part of, you know, you can't really tell who's at fault, you're still going to have to pay for that portion of it, right? And so And these, ever since this McDowell case, the scenarios and the issues have become way more convoluted and gray. And then this is where lawyers, make things complex. It used to be a very bright line. You get indemnification, and unless they can prove that you're negligent, you have to pay a bunch of money. Well, this concurrent negligence, now there's proportionment. So if you're 60% at fault, or 30% at fault, or 5% at fault, and you've promised to indemnify them, then or they promised to indemnify. So what happened here? This is a 3-tier thing. You didn't really explain that very well. I apologize. So general paid the indemnification. Sub said, hey, we'll indemnify for our stuff. And the court was like, well, since it's already been paid out, you have to pay for your proportional amount of that. And that was a surprise to the Austin company, and it ended up putting them out of business. And they had to restructure, and it was a big deal. And just one little provision in page 5 of 45 on a contract. So this is what I mentioned before. I wanted to go back to this, looking at contractual documents. As you're looking at what's being incorporated in there, some of the things that people forget to look at is not only the plans and specs, but often the safety manuals and the insurance documents. I had a client who was an online retailer. They sold Seahawks tickets, and they basically brokered them. They'd buy them from people and sell them, and they kind of did the day trading of sports tickets. Well, they got sued because they couldn't fulfill an order, and they went to their insurance company, who had been insuring them for 20 years, knew that they were an online business, knew they didn't have a physical presence in any state, et cetera, et cetera. And the insurance company said, oh, well, we can't help you protect you against this claim because your insurance only protects bricks through your window at your business, which you don't have, and slip and fall issues if somebody comes onto your premise and gets hurt. And they said, well, we've been paying for this insurance for 20 years. How come? And you guys knew we were an e-commerce company. How is that possible? And they said, well, you saw the application. You've been paying the premiums. It's not our fault you didn't read the policy. And so oftentimes my clients will go through and they'll see the 1 million per claim, 2 million aggregate insurance requirements, and they'll be like, good, I got a GCL policy, I'm good to go. And they won't send the contract to their broker, or they won't open up their policy and look at the exclusions and go, oh, this actually doesn't include contractually promised indemnification. And so now when I get a claim for indemnification, I have to pay it out of my own pocket instead of paying it by the insurance. And so all of this is part of the contractual language. And I think that all of it helps us allocate risk really effectively, because if you get in a dispute and your insurance company can come in like a superhero, pay for your attorney and pay off the other side, and it's all dealt with and done, because that's all the insurance companies want to do, is they want to minimize time of dispute, and even if they have to pay out a little more. That's why we can't have nice things, because we've ruined the insurance world, but that's a whole nother thing. I think understanding and having copies of all of these ancillary documents is super critical as you're getting to the point of securing these jobs. So let's talk real quick. Let's take a step back. Let's pause for a second. Go to Rose's inspired question about this subcontracting that she's going to be doing, and when you make that decision. Typically for my clients, they'll come to me and they'll say, look, we got this job, and we think we can get more of it, but we need to hire some help. We need somebody to come in who's a minority owned business to bid on this piece, or we want to do a joint venture with so-and-so because they have the skills or the extra equipment or something we need. And I think that the biggest factor for all of them in making this determination is risk. Attorneys are scared of their own shadow. That's what I do, right? Like, I'm supposed to stay over here and live vicariously through business owners who take all the risk. And the business owner looks at the risk and says, okay, what is this going to cost me? And can I take that risk? And so when I do the analysis, typically for my clients, it involves saying, okay, can we contract away the risk? Can we insure the risk? And if we can, great. Then we move forward on the job. But if it's one of those risks that can't be contracted away or can't be insured against, I typically advise my clients not to sub that work out, because there's no control at all on how things are going to be handled should things go sideways. And that's the biggest thing you lose with subcontracting. Now, you can indemnify, you can have the subcontractor indemnify you. You can have the subcontractor have no choice but to pay your legal fees, and you get to take over on the dispute. But that's after everything has gone sideways, right? We want to be able to control the job site and the performance of the work to such a level that we can minimize that risk that we can't insure or that we can't contract away from. And so I think that if you have the opportunity to do some painting rows and you have the ability to subcontract that out, I think that's a very insurable and contractual risk you can take. Now, if you come in here and said that, hey, I wanted to do some asbestos abatement, and you were going to try to sub that out, I would advise you against it, because that's very specialized, right? And you got to make sure that you know how to do that stuff properly. And whereas, you know, electrical work and contracting and painting, some of those are skills, it's true, but they don't require and they don't have the high risk danger that's going to maybe trip your insurance to say, hey, you can't do this work. That's one advice I would give you, right? It's the difference between a contractor and a roofer, right? Roofers have way more insurance requirements because they're up on the ladder and they're going to die if they fall. Whereas contractors, as long as they don't go on the roof, their insurance is way cheap. And so if you're going to take on a sub and you're going to make them get insurance, I'd make sure that your insurance covers their job, because oftentimes if you expand your scope from what you told your insurance company you were doing initially, then that can throw things. And it's nothing. It's like a 15-minute phone call. Your broker goes, great, I get some more money, $10 more a month, and here's your new policy, right? Like, it's really not that big a deal, but you have to understand those risks. And that's typically how I advise my clients to walk through this analysis. And a lot depends, obviously, on how big the job is and how much money you want to invest, and doing it one time versus doing it 3 times or 10 times, right? If you're going to do it a lot, maybe it's worth putting a little money into it and making sure it's done right. I do think that getting a good subcontract agreement in place is vital, and the cost of doing such is not prohibitive. And you can create such a document that you can use over and over again in other things. Does that answer your question a little bit, Rose? Okay, feel free to chime in anytime on anything else. Like I said, if you guys don't want to talk about this stuff, you want to talk about, you know, something else, let me know. We can change topic. I'm happy to. I like participation though. So, oh, here's a provision for you. So I had a client bring this contract to me, and I had to clip it because it was super interesting. They wanted the subcontractor to agree to all of the subcontract documents, which is a defined term. It's capitalized. And what lawyers like to do is they like to capitalize terms and then define them in some other part of the contract. Well, I went and looked up what subcontract documents mean, and the list was a page long of documents. Everything from policy manuals to employee memos to bulletins, and anyway, it was huge. But the point is they wanted us to agree to that after we executed the contract, not before. They didn't want to give us access to it beforehand because it was a big pain in the butt, and there was a lot of documents, and it took a lot of time, and we might get scared off or whatever. Probably more just because it was more efficient to not worry about it, right? But that's one word in a contract that I recommend for clients. Not only do we change it, but that we see all those documents before we sign it. And so these are the sort of things when I talk about knowing a contract is what I really mean. You know, not just the broad strokes, but the fine details. And you know, I'd like to say that being a lawyer, this is rocket science, and that, you know, you read this sentence, you would have known that after is not as good as before. But I think that what this really is business owners making the decision to go, okay, can I drive the vision of the company? And can I make decisions from day to day? Or do I want to spend my time reading the minutia of a contract so that I know what my risk is? And that's where attorneys come into play, right? Is that we can take that off your desk. So one of the other things, going back to this incorporated by reference, every time you have a prime contract, it's incorporated by reference. And every time a client sends me a contract to review, it says, and you'll agree to X, Y, and Z incorporated or as defined in the prime contract. One of the things that's interesting is when there's conflicting provisions between the subcontract and the prime contract. Typically what happens is the court will interpret that clause to be overwritten and allow you to change the main contract, which is beneficial, right? Because that's all you were disclosed, or that's all that was there. However, if the prime wants to decide to fight that, it can cause lots of angst and cost to get to this point. I recommend that if there's anything referenced at all, we go fight it, we look at it, and we make sure there's no conflicting languages, because what a contract's purpose is really to set clear expectations. And if expectations aren't clear, contract's not doing its job. And it doesn't do anybody any good to create a contract with gray, fuzzy language in it. And so I think that that's, again, something that I want to stress to you. All right, so let's talk about, first off, questions. I've been talking for a while here. Danny, Alan, you guys listening, or are you just kind of doing work? All right, come back to me, no stress.
Hey, Reuben, I have a comment.
Yeah.
Julie mentioned this before, and I think you mentioned it a little bit ago about challenging the standard comments, challenging the standard clause. I see it a lot with small businesses, especially around insurance. And I just had another client challenge the standard insurance clause in her contract, and in seconds got it changed from a $2 million liability insurance rider to like a $50,000 one. So like her insurance costs went down. And I think a lot of times the businesses are like, I must follow the clauses that are in here. I can't challenge them. They're written in stone, but they really need to be able to say, hey, can this be changed? Does this apply in my situation? And what situation should this stay or change?
No, that's excellent. Thank you for reminding me. Yeah, this is probably my biggest pet peeve, is that companies have spent hundreds of thousands of attorney hours creating these really complex, thorough, amazing contracts so that they can do, you know, business between Lockheed and IBM, right? And then along comes a painter and they're going to paint one room in an office building, and they send them this huge, overly sophisticated contract that doesn't really apply at all to their circumstance. And it's really, really easy for you to go back and be like, this doesn't apply to me. How about we take this out? I don't need to take this risk. I don't need to go buy new insurance for this job. You know, the cost of this contract doesn't need me to have a $5 million policy with automobile coverage, right? It just doesn't need it. And so I agree wholeheartedly. You'll never get anywhere in these contracts unless you ask. And sometimes it's scary. Sometimes business owners go, look, I'm just happy to have the work. I'm just happy that they're even considering me. I don't want to rock the boat. I just want to sign this thing and get it done. There's a time crunch. They sent it to me 3 days ago, and I was supposed to get it back to them 2 days ago, and we're supposed to start work tomorrow. I don't have time for the attorney to look at this thing, and I don't have time for him to cause problems. Like, all of those are great excuses, but at the end of the day, what's more important is your business's success. And to be honest, I personally believe that if you're going to work for somebody or you're going to take a contract job, having them respect you as a business owner and not try to shove their contractual language down your throat because it makes them comfy, will get you more work in the long run. They will see you as a peer. They will see you as someone who will, pay attention to those details right from the beginning. And that, I think, will garnish you more respect than simply saying, whatever you need, I'll take it. I once spent negotiating a contract with Facebook. I probably spent 6 days going back and forth with their in-house counsel about removing some contractual provision because my client wouldn't do it. And finally, we had to get them on the phone, and we had to get Facebook's business person and my client on the phone because the lawyers weren't budging. Right? I'd been given direction, and their in-house counsel had been told don't budge, and the business person in Facebook, after 27 seconds of us talking, said, "Change it. Let's be done. Let's move on," and it was done. Right? And that's the thing is sometimes you get you have to, if it's important, you can even negotiate with Facebook, right, and get it done. So I appreciate you bringing that up. Thank you. So moving on here with knowing your people, I think that words on a page are great, makes, in black and white. But if you have people that don't know how to read, don't like reading, never spend more than 5 minutes looking at anything because they're riddled with ADD, right? Like that's why I like Twitter over Facebook, is because I can read 100 and however many characters versus anything else. It's incumbent upon you as a business owner to understand who you're obligating under your contract, right? So if you have a project manager who needs to do certain things because the contract requires, quarterly reports or what have you, and you know that they're terrible at remembering those things, and they're going to be late or they're going to need extra time, then we should contract around that. We should deal with that. I think that too oftentimes the person reviewing the contract forgets that other people are going to have to be compliant with it, and that includes basic things like data and security protection and privacy issues with passwords and logging in and site visits, right? I think that those things we need to take into account, that the person on the ground, the frontline employee who's there day to day on the job site has to wear the hard hat and the safety gloves, et cetera, and we need to not only craft our contract so that they can be successful, but so that we can help them be compliant. And so as I look through the all of the risks that business owners can take, and all of the varying factors in doing or not doing business, I think if you have good people or you train good people, you mitigate those risks far more than anything. And I think that from my personal perspective, as you're going through dealing with creating contracts and jobs, if you keep your people in mind as you're trying to craft these or trying to revise them, you're going to have a lot more success overall, not only in a project that maybe comes under cost or is actually on time for once, right? Like all of these things are helpful. And so if you're perpetually got a guy that's perpetually late all the time, and his work's great, but he's always a week or two past on his job getting stuff done, give him the extra time in the contract and do it up front, and you'll have I think a lot of success. And I think that we avoid that when we're looking at words on a page, that there's a lot of people behind their actions. So let's talk about some methods of dispute resolution, because if at all possible, I like my clients to avoid conflict. Not because I'm not a fighter, and not because if we need to break out the baseball bat to the kneecaps, we can. But it's costly, and it takes time, and it distracts. And to be honest, we all have way more important things in our life with family and friends that we don't want to be fighting and arguing over money, right? We want to move on to the next job, and we want to get paid for our work. And so some things that I typically see in contracts are, especially in the federal contract side, is there's these big, contract claim processes where if something's gone south, you have to send in a bunch of documentation, and you have to wait for the board to review it, and then they'll either admit or deny, and then you can appeal. It's all internal, right? And I think if you understand what you really want at the end of the day, finding how to craft your contract or revising the proposed contract in a way that lets you, maybe you love just meeting together in a room and going, look, let's hammer this out and let's resolve it, because if we go to court, I don't want to pay my attorney, you don't want to pay your attorney. So let's take litigation off the table. Let's do negotiation. Let's do arbitration, and let's we'll be able to work it out. Or we're gonna just rely on our bonds. Like, that's what I'm putting on the table, and that's all that this job's worth is my bond. And so let's make it easy for us to be able to just do a bond claim and work through going and getting the bond paid out, and that's it. And so I think that looking at how these things can go sideways and really being honest with yourself about what you want at the end of the day and how much time and energy and effort, because I guarantee you, when things go sideways and so has ticked you off or offended you and your emotions are high and you're angry, you're not going to look at it rationally. And you're going to want to go to court, and you're not only going to want to go to court, but you want to take his mother to court, and you're going to want to, you're going to want to hammer him into the ground, right? That's what flying elbow from the top of the rope sort of action. And at that point, it's too late to make the decision or to change. But making it early and figuring out, look, at the end of the day, this contract's, fighting over this contract's going to be worth 20 grand to me. And so if I can resolve this for less than 20 grand, great. I can tell you right now, going to the litigation, especially construction litigation, there is no way you get out of it for less than 20 grand. And so most of the cases that I've been involved with, where there's multiple parties and subs and contractors, we're talking 10-party lawsuits, right, at this point. Have you ever tried to deal with more than one attorney at a time? It's just ridiculous. And that's what litigation is, right? You're going to have 5, 10, maybe 15 attorneys all trying to prove that they're worthwhile and that their bill at the end of the day had value. And so I personally like to avoid litigation through some alternative dispute resolution. I think it's confidential, and it's usually lots faster, and I typically recommend it. But if your contract has arbitration in New York, and you're like, good, I heard arbitration was good. Well, the cost of being in New York for a week to do an arbitration might mean, hey, well, maybe it would have been better for us not to have arbitration so that we could have taken care of something in Seattle, right? So these aren't issues that are one-sided. They're complex, but I think that they're issues that if you raise or look at or think about, we can navigate very, very easily.
Hi, Reuben. This is Tamika again.
Hey, Tamika.
When it comes to conflict, you definitely have to adhere to your contract. I've worked on several projects in several states, and one of the things, like you said, when emotions get high, people are like, no, we'll just go to court. Well, what you have to realize, especially when it comes to federal contracting, is if there is a specific process laid out in the contract, you have to adhere to that process. So if it says first you have to do arbitration, mediation, then litigation, or whatever, you have to follow those steps. And it's critical for you to know that. Again, you want to not have conflict, but a lot of times the contract specifically states the process and how you resolve that conflict and dispute. So just as an FYI.
No, and I think that's a great point. One of the things that I find my clients often missing is the notice provisions in these contracts. So it's like, if there's going to be a dispute, you have to give them 10 days notice. Well, when does 10 days start? It's 3 days after you mail the letter. What? You can't just send them an email or send them a text or yell at them on the job site? No, you have to send them a written letter. There's a particular address it has to go to. The 10-day clock doesn't start till 3 days after the mailing, et cetera, et cetera, et cetera. And those, failing to pay attention to those details can make your conflict not only bigger and more messy, but also, talk about following contractual language. Oftentimes, you're actually obligated to continue to perform your contract even if they haven't paid you. And so there's nothing that burns you more having to perform while you're waiting for 10 days, only to find out that you didn't send it the right way, this claims notice, and you have to start your 10-day period again. And so now you're performing for 23 more days, right? Or whatever it is. And so that can just be detrimental to a small business, because they often don't have the capital or the cash to wait that long to get paid, and then they're unable to perform. And now they've got themselves in a pickle where, yeah, sure, there was a breach on the other side, but now they're not able to perform. And so they've got their own hands are dirty, and it becomes a mess.
Yes, and it's the same on the prime side. So if, for example, Rose, if you were to subcontract work out, and definitely would never want this to happen to anybody, but if for some reason there was a dispute with you and a subcontractor, you could, excuse me, try to resolve that. But again, you would have to go through the process, and in that process, that sub could continue to work even if their performance is bad, and you would have to probably take up the slack as well as still potentially pay them. So not only do you have an issue with their performance, but now you're trying to resolve the conflict, you're still having to pay them, and then you end up having to do some of the work because, again, their performance is not that good. So again, it's definitely a bad situation overall. So
yeah, and I think that, you know, these issues, if you know of them ahead of time and you think about them thoughtfully before you get yourself into the situation, they can be managed, right? The problem is that oftentimes we learn through experience and the school of hard knocks, where we get burned by something and we go, oh, shoot, I'm going to have a contract from now on, rather than dealing with it ahead of time. And so I think that, Tamika, those are great examples. One of the things that happened to a client of mine was actually the flip side. The subcontractor just bailed. And by the time their contract, you know, you go through the notice of a claim and the notice of default, and you were able to terminate their contract, the job was supposed to be done. And so they had to go in and do the job before they even were able to send out the notice of breach to the subcontractor, who just disappeared off the face of the earth.
yeah.
And so I think that even, you know, there's a lot of bad that can happen, but I think that you can navigate this to avoid, to minimize the time in which disputes can occur.
Right.
There's also, you know, one of the things I love to put in contracts is liquid damage provisions, because
Yeah.
it makes it really clear what's at stake, and you can easily, you know, determine, okay, is it worth the 20 grand in the liquidated damage provision, because that's all I'm getting is 20, because that's what I put in the contract, or whatever is the number.
Yeah. I just noticed in the chat,
Oh,
I cannot pronounce the name, Ezekiel De Sosa, stated, I just finished a job in July and I still haven't gotten paid. Lawyer recommendations. I'll definitely give that one to you, Reuben. I've dealt with that before, but I'll give it to you because you're the attorney.
no, I appreciate that. And so, Ezekiel, this happens all the time, because people do jobs on a handshake or a purchase order, or, you know, for a friend, and they're just like, okay, we'll get you paid as soon as the job's done, or what have you. And they end up not having teeth to go and say, hey, there's a dispute. So if you found yourself in a situation where you did a job and you haven't gotten paid, my first question to all my clients or people that call me on this is, so did you have a contract, and you know, did it say how you were supposed to get paid? And, you know, you're on mute, my friend Ezekiel.
Sorry about that. No, I did not have a contract, but I do have some emails, and like I have, like, you know, work that I perform, and like you know, some witness that saw me do the work, and I just don't have a contract. At the time I didn't have one, which was a mistake.
Yeah, of course. No, I mean, this is life. This is what I was saying. We learn by the school of hard knocks, right? We go through the experience. So contracts can be oral or written, and even an email can be a contract. The problem is most emails don't have a dispute resolution provision or a bond requirement or an insurance requirement. they could, if you would have sent the emails, yeah, sure, I'll do this job if you could promise me you have a bond of $50,000 to pay me, should you not, blah, 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 right? Like, you could have put that in your email and that would have been a contract. So what we have here is a breach of contract, and there's really two avenues. You either send a demand letter that says, hey, I'd like to get paid, I did the work, or you skip that friendly effort and you go and you sue them. And
so we did that, and he asked for what's called a restraining order. So I'm not able to contact him anymore. So now I have to do everything through legal, like through court.
Well, so typically the judge will not issue a restraining order, an anti-harassment order is what they're called, unless if there is a legitimate contractual dispute between the parties. He'll typically say, hey, this is a legal dispute. You guys should deal with this in that way. Now, they will issue a temporary one for like a 2-week window sometimes, kind of automatically. But if that avenue of direct communication has been closed, depending on the amount in controversy, I would recommend moving quickly towards some sort of litigation, because the courts are really backed up right now, and there is no way a dispute like this is going to get resolved in any sort of timely manner, because they're not having hearings like they should, and everything's a lot slower. Can I ask?
So should I get a lawyer?
Yes, you should. How much is at stake?
It's like 16K.
Yeah, so anything over $5,000, I recommend getting a lawyer. Anything under $5,000, I recommend going to small claims court. And sometimes, if it's going to be a big pain in the butt and you can't afford it, 16K is kind of in the middle there. Sometimes I recommend my clients just go to small claims court and get 5K out of them and move on with life. You can't go to small claims court and try to get more than the minimums, but you can represent yourself, and it's a lot faster typically. And sometimes the other party doesn't like the bad press, and they don't show up to court because they don't know how to deal with small claims if it's a business. But ultimately, I suspect you have a claim, and I suspect that you have probably 6 years to bring that claim. That's the statute of limitations on a contractual claim, depending if your email is a contract and your oral agreement is in Washington is a I feel like it's a 3-year statute of limitation on oral contracts. But at very least, you did work and they got value, so they've been unjustly enriched, and they should compensate you for your value that you provided to them. And I would recommend getting an
So where can
attorney.
I find a lawyer?
You send me an email. You send me an email, and we'll find somebody local for you that's close.
Perfect. Thank you.
Easy. Let's talk about some dispute resolution. So one thing that's important, Ezekiel, if you're in King County, anything under $50,000 in King County requires mandatory mediation as a prerequisite. So you can't just go in King County because there's so many people and so many lawsuits. The courts have basically said, look, if it's less than $50,000, you have to do mediation. And so you still have to sue them, but you can force them to go to mediation and sit and look at you in the face. The problem is the mediation isn't binding. It's all voluntary, and it's really to get people to go, look, do I really want to spend $16K with an attorney, or do I just want to pay this guy $12 to have him go away, right? And so I think that, if you're trying to draft a contract, understanding the local rules and the local requirements is super important, right? If you're doing a job that's less than $50,000, and you have in your contract that there's litigation only, and you're expecting to go to court, but you're in King County, you got to realize that you have mandatory mediation as part of this process. And so what I would recommend is if there's a dispute, you put a contractual obligation in there to fulfill the King County mandatory mediation requirement within 30 days, within 15 days, right? If there's a problem and you send notice of the problem, there's no reason not to get that mediation done ASAP. Now, sometimes strategically, if you're the one bringing the claim or you want to find some evidence because you don't really have a lot of evidence, that might not work. But oftentimes with contractual agreements, it's pretty clear what was expected, what work was done, and what wasn't paid. And so those are things that I typically talk to my clients about as we go through the dispute resolution. The other things to consider, oftentimes clients will sign contracts for agreeing to laws in other states because they, again, don't want to make changes, don't want to ask for it. So I got clients that all the time get sued in Delaware because they're like, well, everybody said Delaware is a great state to have, you know, business provisions in. And it's like, well, no, you're here. Delaware is expensive. You know, we need to change it. And sometimes it's too late. Sometimes they don't have the authority or the ability. But most of the time, if the other side won't change where the dispute is taking place, it's likely that they're not somebody you want to do business with anyway. It's very easy to craft a provision here that makes it fair for both sides. And one of the solutions that I come up with often for clients is that whoever decides to sue the other party, so plaintiff or defendant, the lawsuit has to take place in the home turf of the one that got sued. So effectively sets up expectations so that if you're going to, you know, if it's big enough to file a lawsuit over and file a claim, then you're going to fight that battle against in the same place that you're, you know, whoever you're suing. So it makes the decision to sue a little harder, but it also makes it a little easier for a resolution to occur for those that you know, need to go pursue something. One of the things that I get lots of questions on these as we're dealing with disputes is clients ask me, hey, should I do arbitration or should I do litigation in my contract? And, you know, there's pluses and minuses of both. Typically, arbitration's quicker, less formal, more confidential. Problem is you don't get the right to appeal. You're kind of stuck with the decision of the arbitrator, who is oftentimes a retired judge or a panel of three. Litigation, you know, it's the luck of the draw on that one. You get to you don't get to pick who your judge is. The schedule can take forever. Discovery is always costly because there's really strict discovery rules, and you end up having to give away a lot. But you get to appeal. So there's plus and minuses, and typically, depending on the matter, the cost involved, and the parties you're contracting with, my clients often choose arbitration just to avoid costs. But there are a few clients I have that want the threat of litigation out there and understand that nobody likes it, and so they keep that in their contracts as a deterrent. And so these are really case-by-case situations, but I think it's something important for you to make a determination on and understand with your eyes open on that. So who just joined us? How do you say her name? Is it Nayam?
She's a presenter following you.
Oh, cool.
Mhm.
Awesome. I'm trying to remember what time, Tanya, where am I at on my time? I have way too many slides and I could talk for days, and it's a problem I have. The wife has told me to be quiet more than once.
Oh, no, you're fine. Right now we are in Q&A, so you've got about another 15 minutes. If there's questions or if you want to just keep on talking about, you know, litigation or arbitration.
Yeah, so let's do this. You have 15 minutes to ask me whatever you want. If you want to be like Ezekiel and talk about your own situation, something squirrely you want to ask a question about, great. Or if you had a conversation over Thanksgiving that you're like, I'm pretty sure Aunt Myrtle was wrong about this, Reuben, can you tell me the right answer? Like, jump in right now. This is your chance to talk to an attorney. Won't charge you for it, but we're going to keep going, but feel free to interrupt me. There's a lot to, when you're talking about dispute resolution, we can go on for a while. One of the things that I wanted to talk to you about is a statute of limitations. I mentioned it a couple of times, mentioned it to Ezekiel. Well, in arbitration, if you don't draft the provision correctly, you can end up not having a statute of limitations. And so 15 years from now, you could have a subcontractor sue you for breach of your contract and take you to arbitration, because under Broom v. Morgan Stanley, the court decided that if you don't specifically put in there that it's subject to normal statute of limitation issues, you're not limited. And so it was a really interesting case. Came out in the late 2010s, I guess. And it came out in 2010 exactly. And it changed how we drafted arbitration provisions since then. So a lot of times these big companies will have contracts that they crafted a decade ago, because everybody still thinks it's the 90s, right? And they won't have changed their arbitration provisions. And so pay attention to these, and in your own contracts, having a statute of limitations, and even having a shorter statute of limitations, I typically advise for my clients, meaning, hey, if somebody's going to sue you, they better sue you within a year. Otherwise, they got to just forget it and move on with life. And so that's something I typically recommend. One thing I do like about mediation is that if the dispute isn't worth that much money, oftentimes you can ask it to go to a mediation and get something resolved, maybe not to your full satisfaction, but quickly. And I find that there's a lot of great resources. One of my favorite places to mediate is down in Tacoma. There's the Dispute Resolution Center down there. And they have a great platform and great mediators. And the key to good mediation is to have a great mediator, because if you have somebody that can really talk some sense into the other side, then you end up being super successful at mediation. Sometimes I've gone days. I've gone through a 2-day mediation where nothing really good happened and we just wasted our time. But more often than not, it's worth the effort. Sometimes though, if people's feelings are hurt, or you can tell it's not going to get solved, you can ask the court. Even in King County, you can ask the court. The mediation is futile. They're not going to come to any resolution. So let's just bypass it. And so I've done that in other times, but I think that if you're going to put a mediation provision in your contract, you want to make sure you cover all these things, right? How you select the mediator, who's paying the fees, whether the mediation is binding or non-binding, whether or not there's action that has to occur after the mediation, et cetera. So I think that this, avoiding claims, there's a lot of things you can do. There's a lot of ways for you to manage your risks. I think that personally, I believe that people don't talk to their attorneys enough, probably because they're either, boring people or they cost too much money. And so I have made a promise that I typically try not to charge my clients to talk to me. I've avoided billing by the hour for a long time. I bill on a project basis or on a retainer basis, because I believe that communicating with your attorney is essential for you to avoid disputes. And I think that if that's the one piece of advice that I could give you, figure out how you have a relationship with an attorney probably. If not, call me. But again, I don't want to take anybody's relationship, but talk to your attorney, talk to the people that you know, and say, look, I want to be able to communicate with you more. How can we make this happen? Because I feel like I need your advice often, especially with growing businesses. I think that it's more critical in those times of growth to set these things out. Tamika, you want to say
Reuben.
something?
Sorry, I'm taking up everybody's time and comments, but one thing to note, if you are dealing in construction, have a construction attorney. Do not go to a tax attorney who is used to, dealing with the IRS. It is critical for you to have an attorney that specializes in what you have an issue with. Reuben is talking about contracts. He's talking about construction. Obviously, he knows what he's talking about. That's his expertise. If you go to him and talk about wills and trusts, he may be able to tell you a little bit, because again, most attorneys know a little bit about every part of the law. But if you have specific questions and issues related to construction and contract law, you need to have an attorney that specializes, or at least 70 to 80% of their time deals with those issues. Because again, it could be the difference in you either understanding exactly your contract and making changes. And again, if you have a dispute, winning that dispute or not winning that dispute.
Yeah, and I think that's excellent, Tamika. Thank you for that. I think that too oftentimes we have a family friend who is an attorney, or a buddy who's an attorney, and they might do criminal law, or they might do personal injury, and you ask them a contract question and they think back to when they were in law school and try to remember. But some of the things that I've shared with you today, I hope show that yeah, having a little more knowledge than just a cursory overview is super helpful, especially in this area. It's complicated enough, contracting with governments and federal agencies, that I think it's worth finding someone that does that all the time. So again, I want to be respectful of everyone's time, give everybody a break as well for the next presenter. So feel free to reach out. I try to pride myself in being accessible. And if I can ever help or be a resource, or find you somebody that's that you need, please feel free. Thank you so much.
Reuben, thank you so much for covering all of the, the contracts, like what we need to do, what we need to be aware of. Just everything that you talked about is really valuable for our small businesses. And that is true. If you are a construction company, like Tamika said, you need to have a construction attorney. If you're a construction company, you need a construction CPA, somebody that understands that, not just, the person down the road that doesn't. So make sure that you're going to the specialist. So this afternoon, we have presenters that are also going to be talking to you. These are local, and they are technical assistance centers that can help you. They provide support services. And so the first up is, we've got Nambura from the African Chamber of Commerce. And so before Nambura takes over and starts hers, I just wanted to say, Reuben, thank you a lot. Thank you very, very much. I mean, a heartfelt thank you, because I know that I know when you talk to our A&E firms, you said that you did this and the reason why you did this. So I know there's a few minutes left. Can you tell everybody in the construction side why you decided to do this?
So my father was an illegal immigrant. I think he got deported more than 20 times but he came to America, married my mom. He didn't speak or read English, but he raised 3 beautiful kids to go to school and graduate from college. And I feel an obligation to give back to my community and to help people. I feel that there is nothing more important I can do with my time than to give it. And I'm positive that good people will see that, and we can make each other better. And so, I take inspiration from my father's journey, that all of these challenges can be overcome. We just have to have the right people in our lives at the right time. And so hopefully I can be that for someone. So.
Well, God bless your parents for everything that they've done.
Oh, they put up with me. I mean, it's a lot. So.
But look at the blessing that they've now bestowed on our community. We've got Reuben Ortega, an attorney, from an immigrant family that got deported, so many times. But look at the blessing of that. And so that's why it's important that we understand that here in America, we are a collective group of people that are coming together to form the village, to support each other, not just our businesses, but each other as well. And so I thank you for being here. I thank you for everything that you are doing for our community, for making it better, and for spending your time with us. We really appreciate you, Reuben. Thank you so much.
It's my pleasure, and thanks again. We'll talk later, okay, guys?
All right, thank you.
Bye.
Thanks.
All right, and so following Reuben, we've got Nambura from the African Chamber of Commerce of the Pacific Northwest. and she's going to talk to you about what they do over at the chamber and what kind of services they provide.
Good afternoon, everybody. It's an honor to present this afternoon. My name is Nimbora. I am from the African Chamber of Commerce. I am one of the vice presidents, basically supporting most of the small businesses within the Pacific Northwest that are owned by African immigrants. African Chamber of Commerce, it's not, okay. African Chamber of Commerce is a membership-based business organization. Its headquarters is in Seattle. We're actually housed by the Commerce Department, so we are in the same building as the Commerce Department in downtown Seattle. We have existed for 22 years. Our mission is to promote and conduct environment for trade and businesses, prosperities between the Pacific Northwest and Africa, and also to advance economic development in local African immigrant communities through small business development. So what we do essentially and within a local level is support small businesses that are owned by immigrants from Africa. What services we provide? We are basically work with partnerships such as this, as well as support small businesses in areas that they are not able to access. We are also able to partner with organizations to provide workshops, outreach, information for training, internship, pre-apprenticeship programs, and apprenticeship programs in port-related industries, as far as basically creating those partnerships. We are now currently promoting for small businesses that are in the construction field because they don't know how to access things like the bonding and also knowing how to get certain business licenses. So we are providing that kind of information. We also reach out to small businesses and provide information on how to get certified by the OMWBE. We also provide small workshops and large workshops, particularly supporting drivers or disadvantaged people who have lost their jobs and putting them in construction fields through ANU and other organizations. We also do provide information such as using Vendor Connect or other portals so that they can understand the bidding processes. So a partnership such as this would be helpful and the information provided within all the industries. African Chamber of Commerce, because of the fact that they've been in existence for 22 years, have been a lot of successful it has a lot of success stories. Basically, what the African Chamber of Commerce was started due to the World Trade Organization, which was held in Seattle back in November of 1999. And one of the attendees was Nelson Mandela. And that's how the African Chambers of Commerce was born. And ever since, we have found that majority of African immigrants trust what we do for the community as well as business owners to provide information. So partnerships are really encouraged to join as members. A major organization, which is maybe a prime organization, can join as a member and then be able to seek a connection to a subcontractor, which would be a small business, so that they can link up with that small business to do either a construction project or bid into a project together. That's it for now. Do you have any questions?
Any questions for Nimbora about the African Chamber of Commerce? Can you go back to your second slide, please?
Or is it third slide, I think?
No, the second slide.
Okay.
So my question for you is, if we have firms, like we've got somebody who makes signs, right?
Yes.
And I understand that you're helping the small businesses that are there in Seattle, but do you also help connect the small businesses from Seattle back to Africa if there is a procurement opportunity in Africa or a contract in Africa?
That's exactly what our business is. Yes, we do. So,
So you help with export of product as well?
export and import, yes.
Okay.
Mhm.
Wow. Sorry, that's me. Can I just throw something out there? And this is something we can talk about, just you and I later, I guess. But I am Janet Toth. Can I begin now, maybe?
Hold on for a second, Janet. I don't know if we have anybody else that has any questions
Okay.
for Nambura. Anybody has questions from Nambura from the African Chamber of Commerce, about her presentation? Anybody thinking about possibly providing export to Africa? If you
No, I'm a small construction company, and I would like to know if you guys deal with young adults 18 and over to get into the construction field.
We are actually working with, and I'm happy to report that we've been selected by the Port of Seattle to work on that specific work. We applied for a grant to be able to do the outreach work, and fingers crossed, we are in the last stages of getting that grant, and we'll be able to support anybody who's between the ages of 16 going up in either apprenticeship, pre-apprenticeship, getting into poor jobs, any kind of sectors within the construction. We are working with partners such as ANU, I mentioned earlier, so that we can be able to create opportunities for African immigrants to get jobs.
Oh, good. Well, I would like to contact you. I'm a flagger instructor, and I've been in the Union Hall since 1991, and I would like to help gear the young adult into the correct trade that they would like to get into. It's a good income for people, but we want to make sure that they're in the trade that they're going to last, the trade that they want to be. If you want to do carpenter, do carpenter. If you want to be electrician. So they need help guiding into those apprenticeship programs. So I will contact you later.
Thank you. Feel free to do that. Thank you.
Any other questions for Nambura from our participants?
Yeah, this is Sharon. Is there contact information in the chat, or how can we get a hold of her?
I will provide that information. I will in my chat right now.
Thank you.
You're welcome. Oh, I'll stop sharing.
Okay, anybody else? All right, so you're going to go ahead and provide your contact information in the chat for us, Nambura?
Yes, I will.
Okay, wonderful. So seeing that there's no other questions, I just want to say, Nambura, thank you so much for your time today. Thank you for your commitment to the community and for helping, for helping the community to find jobs, to get training, to ensure that they're successful. Because when everybody is successful, if our small businesses are successful, our communities are successful, right? So thank you for that. And our next speaker that we have with us is Janet Toth from the SBDC.
Thank you, Tanya. I will be connecting with you concerning that chamber, because I hold a business resource roundtable for all the free resources provided to business owners within Snohomish County here in Washington State. And I think your connection will be amazing. We meet probably every 2 months virtually. So maybe I'll talk to you after this. But my presentation is to bring to you today some information about the Small Business Development Center. That is a national program. It's federally funded through Congress and matched by local funding agencies, including universities. We provide confidential, no cost, valued one-to-one advice to for-profit business owners in areas of startups, how to sustain through COVID-19, to growing the entities and advising through succession, with more than 30 of us across the state of Washington in 25 different locations and hundreds more across the United States. A registered client with the Small Business Development Center receives no cost, again, free confidential advice and notifications of the many webinar meetings concerning all levels of business issues. We get you ready for the next step. So how can the SBDC be helpful to your construction industry business? What are you in need of right now? Possibly funding, maybe it's bonding, maybe it's how do you present yourself as a business for contracting, or how do you want to pivot your business for a different type of contracting? Is it preparing your business to take on a larger footprint or more employees to satisfy a new contract? Or do you need to decide just who and what your business is going to do? What is that passion that you're holding back? Maybe you need to prepare and put strategies in place that will allow you to work more on the business rather than just in it. So we are even there just as a good, safe place to discuss your business, just to let yourself go and just tell us with a non-judgmental review that many times allow clients to reset and move forward from there. These are just some of the things that we do as SBDC advisors and how we can work with you. Most of the time, once our clients hear about us, usually they tell those they depend on or who depend on them about the services that we offer so that the whole business structure has an opportunity to be stronger. And that was mentioned just recently too in this presentation. So we enhance that as well by working with all business owners that we can. We help business owners build relationships with other resources that will they'll need to help them in going forward. For instance, if you're in need of funding to gear up for a project, or you need to seek bonding for a project, we can assist you in preparing the information to submit that application to each. Preparation for these two actions is basically the same. So I prepared and I use 5 basic questions to get started. I ask all of my clients to prepare responses to these questions initially so that I can come to know what they see as their business, how they think about the business, and what they would want it to be. Each business is different. Like snowflakes, there's no two alike. There are no two people alike in the way they think about their business. I cannot take a cookie cutter and say, these are all the same, because small businesses are thankfully owned and operated by people who have a passion to make a success out of their work and to feel good about it. So to see inside your business, I ask these questions just as the doctor uses the X-ray or CT scan or MRI to diagnose and advise a patient. I use these questions, or better said, the responses to bring value to my work with my clients. So here are the 5 questions I'm going to give you today. Number 1, what business? What do you do in your business? Has or will it change going forward? And if so, what are those changes you will make? So what business? Number 2, why you? What do you bring to your business in experience, talent, education, certifications, or licenses? And is there anyone else who fills the gaps that you do not within the business? So number 3, why now? What is happening in your industry, in the local market, the city, county, state, country, or internationally that will affect your business? We all know that COVID is there. So number 4, who are your customers? I asked to describe who your customers are and why. Why do people use your business? Do you have contracts in place, or have they been canceled recently? So what's going on with the customer base? Do you have one customer, or do you have 2 or 3 sets of customers? We work with that as well. And number 5, who are your competitors? List the top 3 competitors, their strengths, weaknesses, and then list yours. Please tell how your business is different. What hole do you fill that is needed by the customers? So the 5 questions again, the short version. 1, what business? 2, why you? 3, why now? 4, who are your customers? And 5, who are your competitors? So your responses and the SBDC work with you to perfect your ideas will make your next step so much easier and in many instances cheaper. Sorry, lost my place. It's not good to have me go rogue. So what should you need to have more advertising for a website? Your responses will help the web developer complete the website in the way that best expresses your business, because they will have your presentation of what your business is, not just a verbal response that is not clear or soon forgotten. This costs you money when you do that. If you think of how to present yourself to gain a contract or to primes or subprimes, you first need to define what you can do and what you don't want to do. That is where the responses to the 5 questions flush that all out and define who you are. Tired of not having enough money in your pocket after a project? We use your responses to build a strategy that works for you and would have you finish a project with what you expected from that job. Need employees for the project? Your responses to the questions will help in building a job description and probably an SOP, standard operating procedure, so that the employee will know what is expected of them. The worst thing is if an employee gets to the job site and doesn't know what to do. Time and money is wasted then. So we get in there with the owner of the business to clear the mud, move away the obstacles, and get the job done. We don't fool around about it either. We don't waste time, yours or ours, at getting to the issues and moving forward, if that's what the owner wants. I always tell my clients, I'm just not that mean to make you do something you will not be using in your work to better your business. So basically that's SBDC in a nutshell. Most of us are working very much the same manner. We work as hard as you do for your business. Any questions?
All right, any of our participants have any questions for Janet? Thank you so much, Janet. We really appreciate the information that you bring to the group and what you're doing in the community and serving our community. Thank you for all of that.
Oh yeah, I have a question.
Go ahead, George.
Yeah, I'm just wondering what's the difference between what she does and what you guys do in your organization versus her organization. What's the difference?
Lily, you want to answer that? You want me to answer it?
It's up to you. You work for both, right?
Go ahead.
I'm gonna just George, like with us, with SBTRC, we provide technical assistance in relation to training, like particularly bonding, access to capital, more like the high level for access to capital. Where SBDC going deeper, it's almost like they provide more like a business plan, for instance. They provide more the assistance on how to provide with the a package for when you apply for a loan, like helping you with your P&L, but they're not gonna do it for you. You're gonna do it with their directions.
Right.
So the difference is they're more detailed when they provide the assistance towards the a loan line of credit, because they are under SBA, right?
We're not under them. We're aside to that. We have funding, but we work very much with the SBA.
Yeah, yes.
So are there a version of or similar to Minority Business Development Agency?
Well, with Minority Development Agency, they're only focusing to minority firms.
Are they parallel, but all small business?
No, but yeah, no. So Minority Business Development Agency, I don't think they provide in-depth financial assistance, right, Tanya? Tanya, you work closely with MBDA and SBDC in California. How does it structure when you try to differentiate the services?
So back, George, a long time ago when we were young and we all had long hair and running around carefree without slippers on or shoes.
It's still there.
Yep. Well, back in those days when I had long hair and much skinnier, I'm just saying, what my understanding was that MBDA was funded by the Department of Commerce. And they were specifically set up to help minority businesses. And that's why they're MBDA, Minority Business Development Agency. So that was their focus. The MBDA has service centers, just like the SBDC, just like us at USDOT for the Small Business Transportation Resource Center. However, their focus was to help minority businesses and to help grow those minority businesses. Today, the MBDA also has export centers. They've got 5 export centers located in the United States. One of them is here in California. They've got one in San Antonio. They've got one, I believe, in Chicago, one in Florida. But each one of those export centers targets a certain part of the world, like Asia, Africa, so those different things. But those are like different from the actual business technical assistance centers. Right. And then my other understanding of the SBDC back in the day was that the SBDC was funded by the department, actually through a lot of their funding came through the SBA. They got a lot of their support through that. And what they were supposed to be doing is, this is my understanding, and this is what was explained to me by somebody a long time ago that worked at an SBDC, is that we help people that are private businesses, like small business owners, but they're just trying to stay within the private market, not really getting into the federal market or the state market. And I said, oh, okay. And then PTAC back in the day was funded through the Department of Defense. And what was explained to me is if you wanted federal contracting, that's who you would go to, because they built their expertise in that line of work because of their funding. And so when we started hearing about, capability statements, all these different things, right? That actually came from PTAC, because the PTAC clients needed to go ahead and work on those things, right, for those federal contracts. But then you also have the SBA 8A program. So there's kind of like this crossover, but all of these programs actually will help you with bonding, with finance. And it just depends on the expertise of the center itself too, who they have as their consultants or who they have as employees.
Yeah. So George,
and I knew I'm aware of a lot of that, but still, sometimes it can be confusing, or when you have businesses that you work with that you want to refer to, who do you refer them to? Who's the best mix? But what I would do is if I send them you guys, you guys would figure that out too. So
just open the door. Yeah. Basically, we ask you just to open the door of any of us, and we will get you where you need to be. And the SBDC has changed over the years. I remember, Tanya, back when I was not an SBDC advisor, I was on the advisory council of the SBA and working with the SBDC back 20 something years ago. And the SBDC has come a long way. We work with any types of businesses right now, those that are federally legal. We can't work with cannabis companies. But we work with all sizes, up and small is a misnomer. It's on different levels, depending on the NAICS code. We work with businesses up to 500 employees. So it depends on the revenue as well. But we're no longer just the small business or startups. We're usually thought of as the startup help, but we work with businesses who have been in business for 50 years and all of them. We just welcome anyone coming through the door, and we find a way to help. So
yeah, I want to give an example. I have a client of a DBE company who's applying for bonding and also applying for access to capital. So I help the client and to work to get the bonding information with the bonding producer, and we provide with all this additional support service. And then we also work closely with the client, with Janet office, when the client applying for PPP, to help them to package the PPP package, because Janet Group have the expertise on compiling everything. I mean, we could do that too, but they're more the one who's working closely with EIDL, PPP folks, so when it comes, so I think in my opinion, I don't really like to compartmentalize everything. We work together as a team. It's just like a one company, which is a different division. So that's why I'm looking at it. But so the client's going to move from SBDC to PTAC back to SBTRC, and then they will have the same result. They get the contract, they get bonding, or they get line of credit. That's the end of it. Yeah.
Yeah, and PTAC not only helps with federal contracting, but also on state and local government contracts as well. And we'll help with registrations and certifications, providing technical assistance, reviewing solicitations with clients, and also reviewing their draft responses to solicitations. So we're here to help with any phase or aspect of government, doing business with government agencies.
Or as
PTAC is amazing. So sorry. Sorry.
or as a subcontractor on those government prime contracts. So if you are a diehard subcontractor and you're never going after a direct agency contract, we can still help you navigate those flow down clauses and, you know, finding the registrations and certifications that are important to your primes, and help you understand the language and reaching out to those to market. So anything that has to do with government contracting, we can assist you with, as Daryl said.
So the other beautiful thing about having all of these service providers working together, when we have the PTAC, the SBDC, the MBDA, the SBTRCs, right, the local chambers of commerce, as we all start to work together, creating the village of support for our small businesses. So there is power when you run with a crowd of support services. Okay, and that's what we need to do. We need to support our businesses, but at the same time, we need to train our businesses so that we don't have those conflicts, so that we are well prepared. We get out there, we execute the work, we understand how to get paid, we move on, right? Because nobody wants to waste their time and their energy on litigation or on chasing a dollar. And so that's what our goal is. We come together, hopefully we can all support our community and we can educate all of our firms to be the best that they can be, to be as prepared as we can, you know, as we can educate them for. And then if there is something that they need support with, then we can all come together to support, right? All of us are there to help hold that firm up. It's not just one entity.
Again, everyone, thank you for taking time out. Be mindful that we still have opportunities for businesses, whether you're woman, minority, disadvantaged. Please check out our website. Specifically, I think in the next couple of weeks, we will be having a small works and job order contract meet and greet. So again, I'll send the information to Lily and Tanya and Jessica. That will be paramount. You'll be able to actually meet and talk to not only prime contractors, but our port personnel who are specifically in charge of those contracts for small works and job order contracts, as well as, again, just knowing the contract process. So FYI, thank you.
Yeah. Oh, Tanya, I wanted to say this, George Frost, GW Frost and Associates, but I put something in the chat about the I-405 project. Really still want to get subcontractors, minority subcontractors, women, small businesses all involved in that project. And so the more we get people interested, and you have to fill out a survey, and maybe you have to provide some more information about financials and stuff like that when you get more detail. But it's important. We want to get as many people possible looking into that project, being interested in that project. So you can contact me.
Okay, well, thank you, Tamika, for your comments. And then George, thank you. Anybody interested, Tamika is going to send that out, and we'll make sure that all of our participants that have signed up for classes get that. And then for George, if you are interested, he does put it every meeting. George does post it in the chat. So if you need that information, let us know, and then we can get you in contact with George. Thank you, everybody, for being here. And again, if you need some assistance, please let us know. We are here to serve, along with our sister agencies, the PTAC, the MBDA, the SBDC,
All right, thank you.
Chambers of Commerce. So
All right.
thank you so much.